XRP Army, could we have a bump in the road? Can the SEC's latest motion for summary judgment shake up things for Ripple? This is a question being asked in AMB Crypto. So approximately 3 days, Ripple and the individual defendants filed a memorandum of law in response to the US SEC's motion for summary judgment. However, on the 22nd of October, the SEC filed its memorandum in opposition for the Ripple defendants' motion for summary judgment. This litigation mainly circled around the SEC's argument over the Howey test as flexible and adaptable. One extract from it says that the court should deny the defendant's motion, i.e. Ripple's motion, and grant the SEC's motion because the undisputed evidence shows that the defendants engaged in unregistered offers and sales to securities to public investors. Hence, under the Howey test, the decades of federal court cases applying it, the SEC prevails as a matter of law, the filing added. This meant that Ripple had misread the context of the Howey test, given the unregulated sale of security. Defendants implicitly concede they will not prevail under controlling law, the Howey test. Instead, they attempt to construct their own test from pre-1933 state law by taking out of context two words, essential ingredients. Now, it conceded the defendant's argument may be creative, but is entirely unavailing as their fabricated test decidedly finds no support in law. Ergo, the SEC expected the defendants to register their offers and sales of XRP and make the accompanying disclosures to investors that thousands of businesses who offer and sell securities in the US markets. So this is basically the SEC saying the Howey test is the Howey test, it's not open to interpretation, you've interpreted it incorrectly, Ripple, you should have done it. Jeremy Hogan has come out and said he was surprised at how weak the SEC was on the post-sale obligations issue, and that even he thought he must be missing something. So this does really put a big question mark over the case. It re-highlights that the whole purpose of this is the fact that in the SEC's opinion, Ripple failed the Howey test. However, the Howey test is not applicable to crypto, and that's what Ripple have argued. There's a flexibility to the interpretation that the SEC are not willing to waver on. It's going to come down to the judge's discretion, and that would mean that the Howey test basically gets overruled in terms of crypto cases. So it's a big, big shout from the SEC, and it really could be a big problem for Ripple and XRP. What do you think? Like, follow and comment.